Okay, thank you. It's my pleasure to be here today. And I want to talk to you about something that all of you have done, but which probably very few of you have actually thought about when you were doing it. And it affects all of us. And that thing is contracts, specifically what I refer to as wrap contracts. And so some of you might be wondering, why are we talking about contracts in this class? This is a computer science colloquium and not a law school class. Well, contracts, in case you haven't noticed, control pretty much everything you do online. Not only that, it controls pretty much everything that has to do with software, which is kind of interesting, sort of strange. And the reason it does is by design. It's by design of software companies as well as design of their lawyers. Okay, so wrap contracts affect you both as a producer of software and technology as well as a consumer or user of technology. And I want to talk today about what you need to know in order to use them in an effective way to protect your work, but also what you need to watch out for as a consumer of technology. Okay, but first some context. When you think of a contract, you probably think of a bunch of small print on thick paper that you sign with a nice pen, like this. And the slides are not being recorded because I didn't get permission for all the photographs, so just thought I'd let all of you know who aren't here live. Okay, so usually think of a contract that is multi-page. You've probably signed when you bought a house or what have you. A wrap contract is not this. A wrap contract is any non-traditional, non-negotiated contract, meaning it's a contract presented to you on a take-it-or-leave-it basis in a format that wasn't generally used before, let's say, 1970. In other words, you don't sign it with a pen. Most of you will be familiar with click wraps. That's where you click with a mouse on an accept icon. Or tap wraps, where on your phone you have to tap before you can proceed on whatever it is that you wanted to do online. There are also browse wraps, which are hyperlinks, which say something like terms or terms of use or legal or something to that effect. And those are known as browse wraps. Now, how did we get here? And are these really contracts that are enforceable under the law? Because there's so many of them. Okay. Well, let me start by giving a little context, because I understand that this is not a contracts law class. All right. The model upon which contract law is based, I'm missing a slide there, is two people negotiating terms which are to his or her own advantage. Okay. But with technology and industrialization, we were able to get mass-produced goods, consumer goods, like the Singer sewing machine. Now, these machines were great because they really improved efficiency, right? The problem was they were really expensive, too. So consumers couldn't buy these, even if they really wanted to, because it made their lives a lot easier, made them much more productive. And so because they couldn't afford to pay for such an expensive item, the companies had to come up with a way to allow them to use the machine without paying for all of it up front. Okay, so the installment plan was born. Consumer credit was born. Even more so than the sewing machine was the automobile. It was really the automobile that fueled the popularization of installment plans, and really vice versa, because without consumer credit, there would be no automobile industry, because very few people back then and today can pay for cars in cash up front, the way that you would go to the store and buy anything else. Okay. So these credit schemes were implemented with standard form contracts. Okay. And these standard forms, the terms on these forms were standardized, and there were a few variable provisions, and that was it. Okay, so it was really contracts that helped shape the market for automobiles and sewing machines and other big ticket items like that. Now, standard contracts proliferated because companies found them convenient and efficient for certain standard transactions. And they used them with both other companies as well as with consumers. But while other companies were allowed to negotiate terms, consumers typically weren't. Courts recognized these contracts as contracts, these standard forms as contracts, even when they were contracts of adhesion, meaning that the consumer wasn't able to negotiate for different terms. And so this was very different from the sort of prototype of a contract where you have two people negotiating terms, right, bargaining. And much of contract law, all of contract law up until the era of standard forms, all of contract law was based upon this idea of two parties equally matched and negotiating terms to his or her own advantage. And so courts applied contract law even though this model, the standard for the contracts of adhesion, was very different from negotiated contracts. Okay. These contracts of adhesion can take different forms. Now, up until the past 20 or so years, maybe more if you count notices and so forth, but most consumer contracts were signed. Right? Most consumer contracts were signed. But as you all know, that's no longer the case. And that brings us to wrap contracts. Okay, mass consumer license agreements evolved from a business reality that was confronted by software companies. And this business reality was that software companies were really uneasy with the way that their software could be easily copied, right? It could be easily copied and distributed. And so they tried to find a way to get out of the first sale doctrine. And for those of you who are unfamiliar with the first sale doctrine, that's basically under copyright, the Copyright Act. It says that when you buy something like a book, for example, you can sell your copy of the book, even though you can't make copies of that book. Okay, so you can sell or transfer your copy of a copyrighted item, even if you can't, make copies and distribute otherwise. Okay, so software companies thought, this could be problematic because somebody could buy a copy of our software and sell it, but they could have, in the meantime, made copies of the program. Now, I'm sure none of you ever did that, right? Not even back in the 80s or so. But in any event, so that was one of the reasons. Another reason is because software was very buggy, and so they wanted to put limitations of liability and warranty disclaimers somehow in their product. Okay, so they came up with a license model as opposed to a sale model. So that's why. Even now, even today, you don't buy software. I mean, some of you might have thought you did buy software, but you don't buy software, you license it. Okay, it's a license versus a sale model. Okay, and in doing that, software companies tried to, the reason they did that was they tried to get out of the first sale doctrine. That was one of the primary reasons. Okay. Okay, so the model was pretty ingenious, really, when you think about it, as far as sneaky lawyer tricks, right? But there was a small problem in that you don't want to slow down a sales transaction by having your customer sign something. Can you imagine if every time you bought a software program, you had to actually, you were handed what was it, the egg, what was the company that went out of business? Egghead? Yeah. You went to Egghead, the Egghead store, and they said, here, you got to sign this before you can buy that. You'd say, wait a second, I'm not doing that, right? So they had to come up with a way to have consumers enter into a contract without the transactional hurdle of having them sign something. So the shrink wrap license was born. Remember this, MS-DOS? Okay. Well, the shrink wrap license was named because it was a license agreement encased with a CD, or a floppy, I guess at the time, and it was wrapped in plastic. And so when you unwrap the plastic to get to your disk, the piece of paper would fall out, and that was the license agreement. But the piece of paper that fell out, you did not sign, right? You didn't sign it. But the court recognized in a famous case called Pro CD versus Zeidenberg that this shrink wrap license was a legitimate contract form. And you accepted it when you saw that there was a contract inside. You had the opportunity to read it, even if you didn't read it, and you didn't take the product back to the store. So you had an opportunity to read the terms, and you accepted it because you did not reject it. Okay, so this...
Actually, the notion that you can return software is a fiction.
Exactly. That's another problem.
As they say. And the other thing is, when I read an ad, it says, at Fry's, for sale. It doesn't say for license. So
exactly.
Why doesn't their terminology bind them?
Not only that, with at least a lot of, my guess is that the way they recognize sales is also based on, a sale model as opposed to a licensing model. So from the accounting standpoint. So yeah, I agree with you. And I've actually written papers raising those points because it doesn't really make any sense. But let me take that back. I may not like it, you may not like it, but there is a justification for it, even if we don't agree with the justification. And what that justification is that the courts started to change the rules of contract law to accommodate the concerns of these software companies, because they thought, this is a new industry. We don't want to stifle it with, there were some bad actors in those days who were kind of, okay, there's no law in this area, so what are we going to do? We'll just make copies and we'll start our own businesses selling somebody's pirated software. Okay. In any event, the courts said that this was a legitimate business model. It was a contracting model. It was efficient, and we're going to recognize this as acceptance when you don't return the software, even if it is a legal fiction, as you pointed out.
But it's unreturnable.
Yeah, exactly, right.
And they don't have to use the word sale. That was their choice.
Right.
They could have said for license.
Most consumers are going to say, what? What are you talking about? I'm buying.
That's their problem.
That's exactly right. That's exactly right.
If they're selling bananas, they can't call them oranges.
Well, they are in this case. So after the shrink wrap, you started to see what courts referred to as click wrap agreements. And that's where you have to click accept. Okay. And the court said that you accepted the terms when you clicked because you didn't have to click. Although, as we all know, if you don't click, you can't progress. And the court says, well, so what? There's no requirement that a company has to let you continue on their website. Okay. And then you've got the browse wrap. The browse wrap is the hyperlink. Here it says terms of use. This is an old style Google terms of use. And there, it's a hyperlink to a page containing legal terms, which you accept when you see the hyperlink and you don't immediately get off the website. And we'll talk a little bit more about that in a second. Although I can see that you're already really not happy with the court's analysis, which I like, because I don't think it is right either. Okay, now you start to see what I refer to as a multi-wrap. Okay, and that's where you have a browse wrap, and then you've got the click. So you've got a click to sign up, but the terms aren't immediately visible. They are next to a hyperlink to the terms. Okay.
Is that a hyperlink term?
The terms, yes. Which, of course, I'm probably the only one who's clicked on that. I'm just kidding. I mean, very few people have actually clicked on it. And we'll talk about the design of that in a little later. Okay. So first, we're going to look at these contracts from two sides. First, as a producer of software. like from the standpoint of a software company. And if we were going to use these agreements, how do we employ them so that there's a high likelihood that they will be legally enforceable? And then I'm going to jump the fence and look at them from the standpoint of a consumer and say, what do you need to know because these contracts may be enforced against you? Okay, so the law in this area is still developing. It's very new. It's still developing, and so there are things can change, but there are some things that are sure. And so if I were to, let's say, give some advice, not legal advice, of course, if I was supposed to give advice about how do you make this contract enforceable if you're building a website or something, then I would say you should definitely have a click element on there, okay? So the recent court decisions enforce electronic agreements, either click or browse wrap, if there is, and this is the law here, actual or constructive notice and either a manifestation of assent or an opportunity to reject terms, okay? But what counts for a manifestation of assent is often not rejecting terms after having notice. So really, it seems like what the courts are fixated on is this idea of, was there reasonable notice? Reasonable notice being either actual notice, that there were legal terms that governed the use of the website or the software, or was there constructive notice, meaning that you should have noticed the terms? Okay, that's constructive notice. A reasonable person would have noticed them. So the cases are really kind of messy in this area, and the way the courts apply contract law, the doctrine, the rules of contract law, is very different from how they apply them in the context of other types of contracts. And so it's really kind of a mess a little bit in this area unless you have read through all the wrap contract cases, which I think I have. So I want to give you some general guidelines that might help. Okay. First, there's generally sufficient notice when the consumer has to click in order to continue on the site. So if the consumer has to click and the terms are immediately viewable, or they're contained in a scrollable box, or they're contained in a hyperlink either above or below the icon that requires clicking, like we saw on the Facebook page. Okay, so here's an example. It's kind of hard to see, but those are terms contained in a scrollable box. Even though the terms are not immediately viewable, and you have to scroll down, because you have to click to continue, the courts are likely to say that that is an enforceable contract. Now, there was a point in time in the late 90s, maybe early 2000s, so, where we weren't quite sure whether or not the terms had to be immediately viewable in order to be enforceable. But since then, there have been enough cases that that doesn't seem to be something that's required. Okay. So as a developer, as a user, if you were creating a website, for example, and you wanted to make sure that your terms of use were enforceable, I would definitely have a click element as part of your contract. Okay. So you want to make sure as a developer that your contract terms require that your users click to accept the terms. Okay, now let's jump on the other side of the fence. As a user or consumer of technology or of a website, don't think that just because you didn't click, you aren't going to be bound. Okay, because there are also cases that say that the terms are binding even if you didn't click. Okay, so if you want to be safe, click. So that's what I would say if you want them to work in your favor. But if you're up against them and you say, wait, I didn't click, that doesn't mean that you're not bound by those terms. Okay. All right, so.
Wait, what about minors?
What about?
Minors, if your children do that inadvertently.
Oh, yeah, that's a whole different can of worms. But believe that, this is another area where the law differs, sort of regular traditional contract law differs from online contracts, because Yeah, usually if you're a minor, you don't, the contract is not going to be binding on you. The way they
Can you be a legal person as a minor?
Well, the way they justify that is there is sort of a caveat to the infancy. It's called the infancy doctrine, and that caveat is that to put it sort of simply, it's that if the minor is getting benefits, they have to give the reasonable value of what they're getting. And so if they continue to use a website, then they can't say the terms don't apply to me. So there have been, it's kind of an interesting, again, a developing area of the law as well. Okay, so there's generally sufficient notice when the consumer or the user uses a website but doesn't click in order to proceed, and, okay, so there's no clicking, okay, and they may not have even seen the hyperlink, but afterwards they get a cease and desist letter because they're doing something that they're not supposed to do, that's against the terms of use of a website, and they get a cease and desist letter. So they have actual notice then. Okay. Or they don't click, but there is a hyperlink which is visible on the website without scrolling. And the hyperlink says something like terms of use or legal or something to that effect, like this.
Does the cease and desist letter have to be in paper, or does it have to be on a registered email system? Or?
No, it can just be an email.
So it could appear in a spam bucket and you would never know.
Well, then you didn't get actual notice. So that's not really going to count.
So it has to be like when a process server serves you, the letter has to touch
It
you.
doesn't even have to be that. If you're sending it again, if you're going to send that, you want to make sure they get it. Then you don't want them to say, "Oh, I never got it." But if they respond, in some of these cases, there's been some back and forth in email, and so you can't later say, "Oh, well, I never got that first email." Okay. So here's an example of, at the very top, there's a notice, okay? And you have to click continue to continue. But actually, on this website, you don't actually have to click to continue. You can continue on the website without clicking. But you don't have to scroll down in order to see the notice. And here's another example. Yeah, kind of hard to see, isn't it? Right? You don't have to scroll. Exactly.
Pale gray on slightly
No,
darker.
but
Exactly.
let's read that. That doesn't say anything about terms of use. It says we use cookies.
Okay,
Good for them.
so what that does is, so it doesn't say terms of use, but what you've done is you've agreed to allow them to use cookies. Okay. Yeah, that's all you're agreeing to at this point.
I thought I'd agreed to more.
But here's another one. Okay. So we use cookies to ensure that you get the best experience on our website, but continue to use website, you agree to our use of such cookies. Okay. I didn't find, there are other, actually other websites that have notices similar. I just wanted to give an example. But some of them will say terms of use at the very top. A lot of them, however, don't put the terms on the, so this is a case that says that in this case, the website said, by continuing past this page and are using the site, you agree to abide by the terms of use for the site, which prohibit commercial use of any information in the site. And even though the user didn't have to click, that this was deemed to be sufficient notice. Okay.
They find the terms of use somehow, the user.
Yes, if by clicking on the hyperlink that said terms of use. Okay. Okay, and again here, I want to compare that with another case that if you don't click, okay, and a consumer uses the website, and there's no indication at the time that there are terms that apply or that they're forthcoming, then a court is not likely to find sufficient notice. So if it's at the bottom of a page, no, they're not going to apply. They won't. The terms of use won't apply. I don't know if any of you have fallen for this trick, but sometimes if you buy something online, after you're done, the last page, there's this little notice that comes up that says, get some discount, right? $10 off your next purchase or something like this. And you click and you think it's the same website that you just bought stuff from, but it's not. It's a different company. Okay, so you have inadvertently signed up for this other service, and they will debit you, $5 a month until you notice, and they'll send you an email that sort of submerged in that says that these terms apply, and then you've got to click on a link to the terms. And that's kind of what happened in this case, and the court said, hey, wait a second. They didn't have to click on anything at the time they supposedly enrolled. You sent them an email after the fact, and that's just too convoluted. It's not something that constitutes sufficient notice. Okay, thank goodness, right? Because that's carrying things a little too far. Okay. And
The other case, though, was the automated viewer. It wasn't just, the first case you listed was a web crawler, and they were saying if you're using automated means, then you're assumed to have seen the terms and could thus be bound by them. There were 3 elements there.
yeah, there were a lot of different,
There were 3 elements. But if it's not automated, let's say I use a browser that is defective, and through no fault of my own, that for some reason never displays the words terms of use or the link. It's a defective browser. I've got crappy internet service at home. I don't get that link. I don't see the link. I never saw the link. I have no constructive notice. No matter where it was on their page, they didn't deliver it to me.
Well, see, okay, so the standard is constructive, not actual. You're looking at actual notice.
Okay,
and so the question is, if you have a defective browser, would a reasonable person having a non-defective browser, would they?
They'd be bound, but I'm not that person.
So that's not the standard. The standard isn't whether you have actual notice. It's actual or constructive.
So somebody else could be bound,
frankly,
then
a lot
I'm
of these
bound.
folks, they actually, I believe them when they say they didn't know what they don't remember clicking. There are all these cases where, where people say, I didn't know I was clicking, or I didn't see the link, or what have you. But, and I think, that's probably right, because I'm sure that most of you don't remember most of the times you click, because it's just becoming this reflex, right? But that's not the standard.
Well, no, I wasn't worried about the click case.
She's saying that you did have notice, you had constructive notice. That's
Because
what
it's your
she's
fault
saying.
that your browser doesn't work. I mean, I'm not, see, there is no actual case on point like this. Okay, so there's no actual. Yes, you could definitely make the argument, and if I were you and this became an issue, I would make the argument that I never got notice. But you would have to argue that not just that you didn't actually get notice, you would have to argue that it was a reasonable person. Okay, it's not that unusual to have a defective browser. Okay, so it's really not sort of strange, or you weren't being unreasonable in continuing to use this browser. It was really up to the company to make sure that their images and text display on all sorts of different formats.
Well, I could imagine somebody running with JavaScript disabled in some fancy
Right, and
program,
so
putting all the blinky bouncy crap in JavaScript and not thinking about putting no JavaScript is.
And so there, as far as I know, there is no case dealing with this precise issue, but courts have sort of talked about what if, right? What if, and they without actually having a case on point. And I think that it's going to come down to whether or not it's what you're doing is reasonable.
I think we can all in this room agree that it's reasonable to disable JavaScript.
Yeah, I do.
I'm using old browser that doesn't
Why
have
can't you just make a scam website, Amazon.com, which explicitly has its terms of use. In return for reading this website, if you continue, you owe us $1,000. Click here. You bury it down there in the terms of use.
Oh, I got one.
And then bill them.
Well, you know what? I actually have something for you.
Okay.
Although I'm not sure I'm going to actually get through all these slides. I'm halfway through. But okay, so there is one case out there, Zappos, okay, where the terms of use were at the very bottom of the page, and the court said, wait a second, the terms of use are inconspicuous. They're buried in the middle to the bottom of every Zappos web page, but the user does not have to click on them in order to buy their shoes. And so because of that, the terms of use were not binding, because they were at the bottom, they were not immediately viewable, and the user was never asked to click. Okay. So at least there's some line there, some line in the sand there. Okay, so here's this beautiful flow chart that outlines, was there reasonable notice? And this is kind of the analysis the court is going to go through. Basically, what I think it comes down to is this. The courts are treating these online contracts as notices, the way that you would if you put a notice on your front yard or notice in a store. Okay, so let's say that you have a store and you have a sign that says no smoking. Now, let's say that somebody else walks in and they smoke and they didn't see the sign. It doesn't matter, you can still kick them out, right? It's your store. Okay. What you can't do is they walk in and you have a sign that says, no smoking. If you smoke, it'll cost you $100. And they smoke and they say, I didn't see the sign. And you said, you got to pay up $100. Wait a second. That, we can all agree, is something you can't do. You can only allow that through contract. Okay? And I think what's happening here is the courts are confusing this idea of notice that comes up when you're a property owner or business owner, this proprietorship, when you're a proprietor, versus a contract situation where I don't have the right to take the $100 from you unless you agreed to my terms before you entered the store, right? And that's why when you go to a hotel, you have to separately initial that provision that says if you smoke, you've got to pay $200 for the cleaning fee, right? And that's why they have you do that. It's not that they can't tell you not to smoke in their hotel. They can. The question is, then what? If you break their rules, then what? They can definitely kick you out, but what else can they do? Well, they can't take away something that belongs to you unless you agreed to it. Okay, and I think that's what's going on in this case, and that's why when somebody has actual notice, even if they didn't see on the when they were on the website, they didn't know that they weren't allowed to do certain things. They weren't allowed to scrape the content or what have you, or deep link or whatever it was. If they get actual notice and they continue to use the website, they can't say, well, technically there's no offer and acceptance here under contract law, because you know you're not supposed to do it, and this company has the power to prevent you from using that site. Okay. All right. So the courts have generally said that electronic contracts, digital contracts are the same as paper contracts. There's no difference. Okay. But as we know, they are very different. With a paper contract, you have to sign. And even if you don't have the ability to negotiate terms, like I didn't negotiate with the car rental place today, I know I'm signing a contract. Okay. Online, a lot of times people don't know what they agree to. They don't even know there was a contract. What? I asked my students in my contracts class, okay, so when you signed your contract with Facebook, and they say, what? What contract with Facebook? They don't know. They don't think about it. Okay. The other thing is that the rules are different in that with electronic contracts, the courts apply this idea of notice as opposed to acceptance, right? When you sign a contract, that's acceptance of terms. But when it comes to wrap contracts, they're doing something a little different. They're using notice instead of contract or consent. Under contract law, there's something called a duty to read, which is really a presumption that if you have signed a document, that you've read the terms. Okay, and you can't later say, well, I signed it, but I never read it. Okay, because that doesn't usually fly. And we can understand why that might be problematic if we allowed people to get out of their contracts that they've signed by saying, I never read it. But online, it's a different issue because your so-called duty to read is triggered by constructive notice, this idea that you should have noticed something. So we're getting even further away from this idea that it's fair to hold you to these contract terms. Okay.
By the way, on signing, since we have this small print, I adopted small print, not read. Is that legal? If I sign it in very small print,
yeah, I've
say
seen
not
that. I've
read.
actually seen people, for some reason that's a
Is that legal?
yeah.
Can you argue at least?
Well, we still signed it, so.
Well, with the copy you said I reject these terms, and if they accept, it's counted.
But I guess the question is then why did you sign it? The presumption is.
If I was forced to sign
yeah.
at gunpoint, basically.
Well, okay, so then there's duress. So if there actually was a gun involved, then you.
It wasn't a hardware gun, but.
Well, I think there are some tough situations when we're talking about paper contracts as well, contracting scenarios. But online, it's just getting a little too crazy. And the reason is that like we said, when you buy something, buy some eggs at the store, they don't say, oh, can you please sign this contract here? Okay, if they did, you would say, you know, I think I'll take my business to another store, okay? But with digital contracts, with wrap contracts, the contracts are intangible, they're weightless. You don't even know what you've done, and you don't know how many pages are in there, because it's cheap, right? You can reproduce the terms, and because consumers don't look at them, they're not even aware there's a contract, the terms are much more aggressive. Okay. There's another reason that people click, or sort of that this idea of notice doesn't really make sense when we're talking about the way people actually behave. And it has to do with something called inattentional blindness. I don't know if some of you have, if any of you have seen this video. I actually saw it at a science museum. But there's a famous study by Christopher Chabris and Daniel Simons that involves subjects that were asked to watch a videotaped basketball game. And on one team, the members wore white shirts, and the other team members wore black shirts. And subjects were asked to silently count the number of passes made by the white-shirted players, but to ignore the passes made by the black-shirted players. Okay, so in the middle of this, a woman wearing a gorilla suit walks in and stands among the players, thumping her chest. And about half of the subjects, the participants in the study, failed to see the gorilla-suited interloper. Yes? You were one, exactly. You know, I gave this presentation once. I told this to somebody in a group of lawyers, law professors, and somebody raised his hand and he said, "That's not real. That didn't actually happen." He said, he did not believe that anybody could actually miss the gorilla. I said, that's because this is a still. In the video, you can easily miss it because there are black-shirted players, and you know this person is the gorilla is wearing a black suit, right? And so I actually did too. And so I told him, I said, well, I have to tell you why I saw the video at a children's museum and I missed the gorilla. And I said, it's a video, it's not a still. But he couldn't believe it. He thought, really? I think it was like 50%. Yeah, it's a famous study, right? And
Well, it's not just this.
It was not just one. They replicated, right? Yes.
Well, there's multiple things. And then after you see it again, and you know that you're looking for the gorilla, then they say, did you see this other thing? There's like 4 things you miss.
Yeah, they've done different,
But in the same video. So they tell you, so you see it again, and this time you see the gorilla, but you don't see.
Right, because you're focused on, so my point is that when you're online, you're focused on something. It's not signing a document. Like when you go to a closing to close on a house, you're focused on those closing documents. You may not read them, but you know it's illegal. There's sort of a formal environment there. Whereas when you're online, you're not thinking about a legal environment. You're focused on something else. And so you have all these people who say, I guess I must have clicked. If I couldn't proceed by the click, I must have, but I don't remember it. And the judge after the fact is saying, oh, we don't believe you. How could you not? Because the judge is doing a sort of an after analysis. They're looking at this and saying, well, because they're looking at the notice, they're looking at the click, and they're saying, how could you not have seen that? Well, that's because they're looking for it.
Here's a puzzle for you, Your Honor. Can you find the terms of use link on this page?
Well, but if you ask that question, then they will. But if you say, can you fill out this form? And afterwards you say, where was the terms of use? They'll say, what? Like my students, right? So, but it's interesting that judges impose this duty to read, and the duty to read is that a reasonable person would have read the terms. But the fact is, no reasonable person reads these terms. Yeah.
On that judge, you played the secondary game. I mean, ask the other things.
Oh, you should. Then afterwards,
you would have been. Then he has to agree. Yes, that was sneaky or whatever.
Exactly. There's. So it's not just a matter of, when I talk to other lawyers, they'll say, well, how is this any different from, when you go to a car rental place and you have to sign an agreement, or your credit card company? And yeah, there is an element of powerlessness when it comes to both. But it's different online because there's so many contracts and the signaling effects are really gone there. I mean, you may not agree with what your bank is doing, but at least you know that there's something going on there. Whereas,
I should sign up on a pseudonym.
Well-
Because in California, you can use any name.
Yeah, I mean, that doesn't prevent, let's say that if something happens and you want to do something about it, and so it's not necessarily going to help you in some cases.
Then a pseudonym with not red hidden in it, basically.
Well, I still don't think that's going to help. Okay, so the presentation of digital contracts is also different from paper contracts. With paper contracts, you sign at the end, right? And you have the number of pages that you can. So the thicker the document, the more important the transaction, right? And you can skim paper documents. With digital contracts, you sign at the beginning. Right? Usually, you click before you know what the terms are, and you can't tell how long they are. So, I think that, for example, here, you have to fill out all your information, and then you click sign up. So at that point,
Cookie use before you fill out everything.
well,
You do.
you read the cookie use before you fill out anything.
I certainly do before I click the sign up.
Okay, so this is what most people will do, is they will fill in the fields, okay? At that point, you can click terms, or cookie use, or any of these hyperlink terms. Now, if you do that, do you think you're going to lose everything? Is a new window going to pop up, or sometimes you will lose everything that you just filled out?
That's right.
Yeah, and so most people are going to think, you know what? Even if they're not going to take the risk that it's not going to erase everything they just put in. And they'll just click sign up.
Maybe their mother told them not to read anything that's in upper medium gray over a lower medium gray background.
They probably. I sort of doubt that, but here's another example. PayPal, you fill out all this information. And then you click, yes, I've read and agreed to the following, but they don't even give you the terms. And so at that point, you filled out all this information, which everyone hates to fill out their personal information. And then how many after the fact are going to click on the hyperlink?
It's worse now because browsers will autofill.
Yeah.
Not my browser.
Well, yeah.
Everybody else's browser. Everybody who's not using links.
Okay. So there's a lot of problems with the way with digital contracts because of the form. So you're ambushed at the end. You know, there are also hyperlinks, a lot of hyperlinks. So the contracts are a lot longer, and there's something known as unilateral modification clauses. Okay, and this is a clause that says, well, even if you did make it to the terms of use, in the first couple of lines, it usually says something like, we can change these terms at any time, and you will have accepted them if you continue to use the website after we've changed the terms. Okay. Now, I call that a bait and switch practice because what happens is, like with some companies, like Facebook, for example, they may have privacy provisions that you're okay with when you first sign up. And then you start to build your network, right? You put stuff on there, your network grows, and then they change their terms, and you're not as happy with it, but okay. And then so on and so forth, until you're really not happy with the terms that you have now. But at that point, you've got sunk costs, right? And you're gonna have switching costs. And so you don't necessarily want to change even though you're not happy with the terms. And that's what you get thanks to unilateral modification clauses. There are also other reasons why consumers agree to these terms. There's just too much information with all the hyperlinks, right? There's this sense that, hey, everyone else is doing it, right? Do you want to be the only one not on Facebook? Sure. Yeah, I am. I'm sure in this room, okay, but frankly, I am the only one that I know in my family, and they always say, "What's the matter with you?" But the fact is, if you're not happy with the terms, if you view it as a contract, then you wouldn't sign up. But most of them don't read the terms, so it's like a bit of an ostrich. There's also something known as the optimism bias, the idea that, yeah, there are these nasty terms in there, but the bad stuff's not going to happen to you, right? Somebody else. It's the idea that only the top 10% can be in the top 10%, but hey, when you're in school, you think, well, but that's going to be me, right? Okay. We talked about sunken switching costs, and just the fact that it just takes too much time to read all the terms. Okay, now you think, well, I don't know, some of you might secretly be thinking, so what? I've clicked on so many of these, they didn't really hurt me. What's the big deal, right? Well, the terms actually can be pretty bad. So for example, on this website, you can actually, it says here that, that if you cancel an order, okay, or there's a failed delivery attempt, then not only do you have to pay for the delivery charges, the full cost of shipping and handling, you also have to pay a 20% restocking fee. Okay. It also says that you can't complain about the lousy service on any social media or on a consumer complaint board. And if you do, it'll cost you, and it's kind of hard to figure out, but by my calculation, it's at least $250. Okay. So you can't even put on that Facebook page that I hate this website because they never delivered the good, because then they'll come. And if you think that's not going to happen, actually, not on this website, there was another company that went after a couple, and because they had posted a complaint on one of these consumer gripe sites. And they said, if you don't take down this negative review, under our terms of use, it says that we can charge you, I think it was $3,500. Okay. And so they said, and they tried to take it down. But the problem was the gripe site wouldn't take it down. And they said, if you want us to take it down, you have to go through our arbitration process, and that'll cost you $2,500. Right? But most people are. The funny thing is, these clauses, when you read some of these cases, the early cases, they had to do with opportunistic users, people who were like web scraping content. That's where you get this bad law, right? But what you really don't see are opportunistic consumers who are doing things like this to get around. I mean, this provision is a little out of hand, right? I mean, no. I think that if you actually knew this provision was in the contract, you would buy from another website. You don't need to go to this website. But the problem is you don't, because you don't know that it's in here until what? Until you order something and it comes broken and you try to return it and they say no, and we're going to charge you a 20% restocking fee if you do. So, all right, so what's the solution? Well, I think that we have this duty to read. I think that there should also be a duty to draft recently, which goes back to what Andy was talking about earlier about, I didn't see that, or on my browser, how am I supposed to, this idea of constructive notice. That shouldn't be the only thing we focus on. We should also look at, well, what else could the company have done to make this contract more readable, to more noticeable, okay? And that's not something the courts have considered at all. And this is why I think code has a role to play here. That I think lawyers should not be the only ones drafting these things. We should also look to computer scientists and to web designers and people to sort of implement a contract in a way that makes sense for the user. So look at it from sort of a usability perspective, okay? Right now, the law puts the burden all on the user, the consumer, and it doesn't put any sort of responsibility on the drafter to make contracts more reasonable. They have all the drafting power, right? The companies have all the power to present the contracts. And so the relevance of code really comes into play here, because companies can make these contracts more visible, and they can incorporate transactional hurdles to make consumers sort of wake up and sort of pay attention to certain provisions. Okay. Now, there's a study indicating the power of website design and the role that computer scientists can play in making contracts more visible. So there are some researchers, they're doing research on privacy. There are researchers at Carnegie Mellon that tried to test the impact of reducing sort of privacy concerns. And what they did was they recruited some university students to complete a survey. And there were two versions of the survey. The first was, they called it the frivolous version, and it looked like this. And they asked a lot of very personal questions, okay? And the top said, how bad are you? So it's all very sort of ha, 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 right? Now, the baseline version of the survey looked like this, okay? And it was entitled Carnegie Mellon University Survey of Ethical Standards. It had a very professional look. The questions were the same on both versions, okay? And they both were just as nosy, right? They both asked the same sensitive questions, right? But they found that participants in the frivolous condition, this one, the devil one, were on average 1.7 times more likely to admit to having engaged in the behaviors that were questioned than those in the baseline condition. Okay, so the context, the way something is presented really matters as far as the way people engage with the website. And another unrelated, what happened to the?
Do they have any sense of which of those two sets of numbers is accurate?
Yeah.
More likely to lie.
Who lied more?
You give two different answers. Are you lying on the frivolous one or are you lying on the formal one?
Wait, I'm sorry. Oh, well,
It's the same person.
they were guessing that you're probably telling the truth on the frivolous condition because you weren't as scared about the repercussions of getting found out.
Sure, it'd be
It
devilish you lied more.
to ask if you were telling the truth.
Yeah, no, I think that's kind of what they were getting at. But
Well, there are
there's
techniques, the guys who had to do AIDS surveys, there are techniques where you can get a better count than just saying that, because they're trying to protect anonymity in that particular case. The guys up at UCSF have had to deal with this for decades now.
And so how so?
What they do is they do an anonymization procedure
Right.
where you could flip a coin.
Right.
So think whatever your answer is.
Well, they didn't actually want to get the truth.
Yeah.
They wanted to. I mean, it wasn't because they wanted answers to these questions in particular. They want to know.
The perception of the
not-
two different formats.
Exactly, whether or not people valued privacy differently depending on the context. Now, there's a slide missing here. I don't know where it went. That's why I keep flipping back and forth. But there was another study done by two researchers, Matthew Kay and Michael Terry, at the Human Computer Interaction Lab at the University of Waterloo. And they looked at visual design strategies, and I really wish I knew where that slide went because it was very interesting. They used text bubbles, and they used what they called textured agreements to create visual interest. And they found that when they did, people spent more time, an average of 7 seconds, an average of 36 to 40 seconds on the agreement versus 7 seconds on each sort of page of the agreement. And they also found that longer reading times correlated with greater retention of information. There was another study done that presented privacy policies in a nutrition label, the new style nutrition label format. And they found that people actually read the policies and they actually thought it was more enjoyable to read them. And they were able to retain the information more accurately. Okay. All right, so I'm obviously not a designer, I'm just a law professor. So this is my feeble attempt at making these contracts a little more salient. Okay, so this is from Facebook's page, at least at the time that I copied the page, because they're constantly changing it. This is how they inform their users of what they do with the information. Obviously, it's not presented in a way that is going to capture anyone's attention who's not specifically doing research on this issue, right? Okay, so what happens if you require an opt-in? Okay, it's going to annoy people, right? It will annoy people because the more uses of their information that you seek, the more times they have to click, and the longer it's going to take. But that's kind of the point, right? So that way, you're forced to deal with the amount of information that's being taken from you, okay? But of course, they don't want to do that. They don't want to require opt-in because they don't want you to know, right? Okay. You can also raise awareness by requiring confirmation. So rather than just having one click and you've agreed to everything, why don't you make your users, you send them an automated email after they sign up. They do that anyway, a lot of times, and have them actually type something back to you. You can just have them say, yes, I consent to letting Facebook use my information in any way that it wants, and then you add your name, you type in your name, the date, and the email address. And so that would sort of overcome this habituation, right? Okay, here's an indemnification clause that's currently on the website. An indemnification clause says that in the event that something you do creates trouble for them, you are going to protect them. So you will pay their legal fees. And most people who signed up have no idea that clause is in there, right? And it's a pretty significant liability. I'll tell you in practice, this is one of the most hotly contested negotiated contractual provisions. And here we all are agreeing to them every time we go online. Okay. So how can we make this more salient? Oops. I don't know what's happening to the slides here, but you could put a danger icon, and I had also put in something that you type in and a CAPTCHA just to overcome the consumer habituation. Okay, so this is what it would look like. Okay, so the idea is that the courts have just made things too easy for companies. They've made it too easy to force us to enter into agreements. And so what they should do is really recognize the power that companies have to manipulate and shape user behavior by the way they present contracts, the form of the contracts. And there's a real danger to the contracting of everything, and this is that people fail to take contracts seriously. And the challenge for the law is to incorporate the work of computer scientists and developers to help design contracts in a way in ways that are more effective, and in this way use code to bring some sense back into contract law. So I don't know if there are any questions. Yes?
Don't answer this if it's too far afield, but I've been saying for at least since 1979, I've been saying something which I'll tell you, and after hearing you talk, I think I'm wrong, and I'm going to tell you what I think now, and I hope you correct that, so I can go to the third stage. So I've been saying corporations are just using contract law to destroy common law. And I always use the example of the parking ticket, which says no bailment is created, right? Which is a common law concept which you are destroying by putting it on a contract. Now, after hearing you speak, I think I have to say the courts are destroying the common law are destroying the old common law by coming up with a new common law. All of this is common law, right?
I think that's more correct. Okay, first of all, so common law is the law that courts make. Okay, that's.
Before we had courts, they were just trying the nobles, right?
Well, the way that we typically refer to common law is the law that the case law, right, that the courts make as opposed to statutory. And yeah, I think that what's happening here is that we have this body of contract law, and then we had sort of these changes in the marketplace, and companies responding to these changes in the marketplace by coming up with new ways of presenting contract terms to sort of because contracts come into play when in a lot of different arenas, but the reason we're seeing so much of this now is that the technology is moving a lot more quickly than the law. Okay, and so if you have a company and you're not sure whether or not what you're doing is legal, you're not going to sit there and wait for the courts or the legislators to come down and say, you can do this, okay? So, but at the same time, you don't want to get into too much trouble by doing something you're not supposed to do. So what do? Well, you can resort to private law, meaning if I'm a company and I'm not sure whether or not I can track your movements online and then sell them to somebody, to a third party, I'm not sure that's okay. And believe it or not, I think 20 years ago, people weren't sure that was okay, because it probably wasn't. It seems kind of unethical, you might think. And so you think, well, I'm not sure if I can do that, but I know I can do it if what? If you say I can. And so how am I going to make sure that you say I can? Well, I'll have you sign a contract. But if you sign a contract, you're never going to use my website. I know I'll have to have you sign a contract without knowing you're signing a contract. That seemed to work pretty well. And that's where we have the internet of today. It didn't have to look like this, right? It didn't have to look the way it does now with all the data problems and security issues. But it's kind of where we are, and we kind of have to deal with that.
Two things. One, website designers are not in a position to make these decisions, to say, oh, we're going to present it in a nice way. But
No.
ignoring that particular problem, how can notice work both ways? And by that I mean, Facebook says, to keep picking on Facebook, and I don't think they're especially bad, that you agree to their terms because you've done these things. You've done constructive notice. But Facebook didn't have to, Facebook and I didn't have to negotiate that contract. That's just the contract that they presented and I accepted.
Right.
If I'd presented a contract and they'd accepted, we'd have a different contract.
Right.
So how can I use notice to have them agree to a different contract that perhaps they didn't see because they didn't read my terms, but it's still bound because they had constructive notice?
Yeah, some people have tried that, and I think the courts aren't going to buy that. And the reason is, there aren't a lot of cases. I've actually been, because I've been reading news stories about consumers doing this. For example, they'll send an email to a company and it gets lost. So we change the terms, or they'll do like, you did not read, but they'll say something like, they'll put some proviso in there.
Yeah,
right?
they usually try and do it by writing on the check, this is payment in full for
But
on the first mortgage payment.
Yeah, but that's a different, so that's a different sort of situation. But when we're talking about these automated, or when you're talking about sort of the digital contract, for a while, I don't know if any of you saw, there was something going around Facebook that said something, they were encouraging people to say, I own all my data, or something like that. It was one of these things that kind of became kind of popular. But under contract law, so when you signed up with Facebook, they have a provision that says that they can make changes to their website, to their terms of use. If you make changes and you send it to them, they have to agree somehow. It is asymmetric.
No, they have to have constructive notice.
No, but okay.
I had constructive notice, they have constructive notice.
But see, if you think about it the way that I think the courts, and I think all of us should think about it as a sort of property issue, what is the thing that you are attaching to the notice? What, other than your personal data, right? Which supposedly you agreed to give up.
Which is a thing of value. We've established it's a thing of value. So
and so according to Facebook, the exchange there, the bargain, as we say in contract law, is they let you use their services without charging you money, and you let them use your data. Yeah. So when you put where would you attach that notice? Is the problem.
This is a technical problem. There's no reason the IETF couldn't adopt a standard whereby when you post to a website, there's this protocol, and you can put things in that protocol.
That's the thing. There are, my theory is that if judges only knew what companies could do to make their contracts more noticeable, more effective, more fair, then they might analyze these cases a little differently. But because they're just looking at it in the way it's presented to them, they're applying sort of the physical world sort of textual ideas in this realm that is very visual, and where the presentation of the contract is everything. And instead, what they're doing is they're saying, no, this is just like that parking ticket. But the fact is, it's not like the parking ticket. Why? Because the parking ticket, it has two sides. You can only fit so much on two sides of a 2-inch square of paper, right? But 50 pages, right? If you hit all the hyperlinks, so it's not the same thing. And I think that that's something that tends to get overlooked. And so yeah, you're right. It's not that it's not like the IT folks can actually say, okay, you got to do something, to the marketing people. But that's kind of what I'm trying to do. And if any of you, I think that if there have to be more studies out there about, because right now the big thing in the law is people don't read their contracts. It doesn't matter what you put in them because people don't read them anyhow. I think that's too easy. I think that's giving up too easily. And it's people don't read them because they're not presented in a way that they're readable. And even if people can't change the terms, even if they can't negotiate, it doesn't mean they wouldn't read the terms. For example, that one website I showed you, you can't negotiate with that company, but you don't have to buy from them. Of the book, even though you can't make copies of that book. Okay, so you can sell or transfer your copy of a copyrighted item, even if you can't make copies and distribute otherwise. Okay, so software companies thought, this could be problematic because somebody could buy a copy of our software and sell it, but they could have, in the meantime, made copies of the program. Now, I'm sure none of you ever did that, right? Not even back in the 80s or so, but any event. So that was one of the reasons. Another reason is because software was very buggy. And so they wanted to put limitations of liability and warranty disclaimers somehow in their product. Okay, so they came up with a license model as opposed to a sale model. So that's why even now, even today, you don't buy software. I mean, some of you might have thought you did buy software, but you don't buy software, you license it. Okay, it's a license versus a sale model. Okay, and in doing that, software companies tried to, the reason they did that was they tried to get out of the first sale doctrine. That was one of the primary reasons. Okay. Okay, so the model was pretty ingenious, really, when you think about it, as far as the sneaky lawyer tricks, right? But there was a small problem in that you don't want to slow down a sales transaction by having your customer sign something. Can you imagine if every time you bought a software program, you had to actually, you were handed what was it, the egg, what was the company that went out of business, Egghead? Yeah. You went to Egghead, the Egghead store, and they said, here, you got to sign this before you can buy that. You'd say, wait a second, I'm not doing that, right? So they had to come up with a way to have consumers enter into a contract without the transactional hurdle of having them sign something. So the shrink wrap license was born. Remember this, MS-DOS? Okay. Well, the shrink wrap license was named because it was a license agreement encased with a CD, or a floppy, I guess at the time, and it was wrapped in plastic. And so when you unwrap the plastic to get to your disk, the piece of paper would fall out, and that was the license agreement. The market for automobiles and sewing machines and other big ticket items like that. Now, standard contracts proliferated because companies found them convenient and efficient for certain standard transactions. And they used them with both other companies as well as with consumers. But while other companies were allowed to negotiate terms, consumers typically weren't. Courts recognized these contracts as contracts, these standard forms as contracts, even when they were contracts of adhesion, meaning that the consumer wasn't able to negotiate for different terms. And so this was very different from the sort of prototype of a contract where you have two people negotiating terms, right, bargaining. And much of contract law, all of contract law up until the era of standard forms, all of contract law was based upon this idea of two parties equally matched and negotiating terms to his or her own advantage. And so courts applied contract law even though this model, the contracts of adhesion, was very different from negotiated contracts. Okay. These contracts of adhesion can take different forms. Now, up until the past 20 or so years, maybe more if you count notices and so forth. But most consumer contracts were signed, right? Most consumer contracts were signed. But as you all know, that's no longer the case. And that brings us to wrap contracts. Okay, mass consumer license agreements evolved from a business reality that was confronted by software companies. And this business reality was that software companies were really uneasy with the way that their software could be easily copied, right? It could be easily copied and distributed. And so they tried to find a way to get out of the first sale doctrine. And for those of you who are unfamiliar with the first sale doctrine, that's basically under copyright, the Copyright Act. It says that when you buy something like a book, for example, you can sell your copy, but the piece of paper that fell out, you did not sign, right? You didn't sign it. But the court recognized in a famous case called Pro CD versus Zeidenberg that this shrink wrap license was a legitimate contract form. And you accepted it when you saw that there was a contract inside. You had the opportunity to read it, even if you didn't read it, and you didn't take the product back to the store. So you had an opportunity to read the terms, and you accepted it because you did not reject it. Okay. So this...
Actually, the notion that you can return software is a fiction.
Exactly. That's another problem.
As they say. And the other thing is, when I read an ad, it says, at Fry's, for sale. It doesn't say for license. So
exactly.
Why doesn't their terminology bind them?
Not only that, with at least a lot of, my guess is that the way they recognize sales is also based on, a sale model as opposed to a licensing model. So from the accounting standpoint. So yeah, I agree with you. And I've actually written papers raising those points because it doesn't really make any sense. But let me take that back. I may not like it, you may not like it, but there is a justification for it, even if we don't agree with the justification. And what that justification is that the courts started to change the rules of contract law to accommodate the concerns of these software companies, because they thought, this is a new industry. We don't want to stifle it with, there were some bad actors in those days who were kind of, okay, there's no law in this area, so what are we going to do? We'll just make copies and we'll start our own businesses selling somebody's pirated software. Okay. In any event, the courts said that this was a legitimate business model. It was a contracting model. It was efficient, and we're going to recognize this as acceptance when you don't return the software, even if it is a legal fiction, as you pointed out.
But it's unreturnable.
Yeah, exactly, right.
And they don't have to use the word sale. That was their choice.
Right.
They could have said for license.
But most consumers are going to say, what? What are you talking about? I'm buying.
That's their problem.
That's exactly right. That's exactly right. Okay, thank you. It's my pleasure to be here today. And I want to talk to you about something that all of you have done, but which probably very few of you have actually thought about when you were doing it. And it affects all of us. And that thing is contracts, specifically what I refer to as wrap contracts. And so some of you might be wondering, why are we talking about contracts in this class? This is a computer science colloquium and not a law school class. Well, contracts, in case you haven't noticed, control pretty much everything you do online. Not only that, it controls pretty much everything that has to do with software, which is kind of interesting, sort of strange. And the reason it does is by design. It's by design of software companies as well as design of their lawyers. Okay, so wrap contracts affect you both as a producer of software and technology, as well as a consumer or user of technology. And I want to talk today about what you need to know in order to use them in an effective way to protect your work, but also what you need to watch out for as a consumer of technology. Okay, but first some context. When you think of a contract, you probably think of a bunch of small print on thick paper that you sign with a nice pen, like this. And the slides are not being recorded because I didn't get permission for all the photographs, so just thought I'd let all of you know who aren't here live. Okay, so usually think of a contract that is multi-page. You've probably signed one when you bought a house or what have you. A wrap contract is not this. A wrap contract is any non-traditional, non-negotiated contract, meaning it's a contract presented to you on a take-it-or-leave-it basis in a format that wasn't generally used before, let's say, 1970. In other words, you don't sign it with a pen. Most of you will be familiar with click wraps. That's where you click with a mouse on an accept icon. Or tap wraps, where on your phone you have to tap before you can proceed on whatever it is that you wanted to do online. There are also browse wraps, which are hyperlinks, which say something like terms or terms of use or legal or something to that effect. And those are known as browse wraps. Now, how did we get here? And are these really contracts that are enforceable under the law? Because there's so many of them. Okay. Well, let me start by giving a little context, because I understand that this is not a contracts law class. All right. The model upon which contract law is based, I'm missing a slide there, is two people negotiating terms which are to his or her own advantage. Okay. But with technology and industrialization, we were able to get mass-produced goods, consumer goods, like the Singer sewing machine. Now, these machines were great because they really improved efficiency, right? The problem was they were really expensive, too. So consumers couldn't buy these, even if they really wanted to, because it made their lives a lot easier, made them much more productive. And so because they couldn't afford to pay for such an expensive item, the companies had to come up with a way to allow them to use the machine without paying for all of it up front. Okay, so the installment plan was born. Consumer credit was born. Even more so than the sewing machine was the automobile. It was really the automobile that fueled the popularization of installment plans, and really vice versa, because without consumer credit, there would be no automobile industry, because very few people back then and today can pay for cars in cash up front, the way that you would go to the store and buy anything else. Okay. So these credit schemes were implemented with standard form contracts. Okay. And these standard forms, the terms on these forms were were standardized, and there were a few variable provisions, and that was it. Okay. So it was really contracts that helped shape